Exemptions. Not all offerings of securities must be registered with the SEC. Section 3A outlines various classes of exemption securities. And Section 3B allows the SEC to write rules exempting securities if the agency determines that registration is not needed due to, quote, the small amount involved in the limited character of the public offering. Remember earlier I told you you're going to be taking a small percentage of the value of that birth certificate and you'll be giving it to them to use as a public offering, to which they will be giving you a dividend cash flow back based on what they make. That's why this is what I mean when I say you'll be giving them a small percentage of the value of that birth certificate. The value of that note attached to that birth certificate as a collateral. Section 4A2 exempts transactions, quote, transaction by an issuer not involving any public offering. You are staying private in this entire thing. You're not the one engaging in a public offering, other parties are. Those other parties will be compensating you for its use, which has historically created confusion due to the lack of specific definition of, quote, public offering. The Supreme Court provided clarification in SEC versus Ralston Purina Code. Some exemptions from the registration requirements include, meaning these are some, not all, but some of the qualifications for exemptions. Exemption from what? From registering with the Securities and Exchange Commission. One of it is private offering, aka private placement memorandum, to a specific type of limited number of persons or institution. So now you see that your PPM is a form of offering, but privately. You offer a specific percentage to them. Remember, we mentioned something about offering when it comes to takeover. Go back and listen to that portion of takeover. We mentioned about offering, cash offering. We went to the definition of what cash is and proceeded in the UCC. Right, that PPM is a private offering on the closed end. You've closed it. And then when they begin to take that small percentage and begin to do an IPO on their end, because they will fall under all the scrutiny of regulation of licensing, that private offering agreement is you would give them part of your equivalent interest for them to use, and then they'll be giving you money based on what they make. You're not doing anything publicly. Offering of limited size, meaning a small percentage of that collateral. Interstate offering and securities of municipal, state, and federal government. The first two mostly applies to you. Rule 144. This specific Rule 144 tells you exactly what you need to do to qualify under the exemption. Rule 144, promulgated by the Securities and Exchange Commission under the 1933 Act, permits, under limited circumstances, the public release of restricted and controlled securities without registration. In addition to restrictions on the minimum length of time for which such securities must be held and maximum value permitted to be sold. Listen to this, because this will be a part of the language in your PPM. Terms and conditions. As to the period they're going to use it, and the maximum amount, and the specific percentage that you will be providing to them for them to use. The issuer must agree to the sale. If certain requirements are met, Form 144 must be filed with the Securities and Exchange Commission. And this Form 144 is just a 2-page document, this odd-looking brochure-like document that they will be filing. They'll be giving you a copy. Often, the issuer requires that a legal opinion be given indicating that the resale complies with the rule. The amount of securities sold during any subsequent 3-month period generally does not exceed any of the following limits. In other words, they're giving you a cheat sheet of what your terms and conditions of how, when, and the duration of that public offering that they'll be using that you're renting out to them. It'll be 3 months. Interesting enough, 3 months is per quarter. And what will be the increments that you'll be giving them based on the percentage of that promissory note? So your promissory note so say for instance the collateral, aka the mortgage that you have as part of the equitable interest of the trust being a secure party to that is legacy, and the birth certificate being used as collateral, and the birth certificate attached to said collateral. Say the amount was 1 million bucks. You will take 1% of that and you will be renting it out to them every 90 days. And the average weekly reported volume of trading in the securities in all national security exchange for the preceding 4 weeks. That the average weekly volume of trading of securities reported through the Consolidated Transaction Reporting System, aka NASDAQ, aka public offering. You be giving them 1% of it. 1% of your equitable interest of whatever value that promissory note has is what you'll be renting to them every 90 days. If you want like a lease for a property, you can make it continuous after the 9-day period, or you can make it end there completely. And then they cash out to you. And then you show them how you're going to cash out, which is going to be through postal banking. Postal banking is basically almost like a nexus or a gateway. Like PayPal is a gateway payment processor. That's how you be using postal banking. But just so you know, this Rule 144 applies solely to those coming to you. What applies to you is something called 144A, which is a safe harbor clause within the Securities Act of 1933. Right here, SEC Rule 144A. Rule 144A of Securities Act of 1933 is amended, quote, the Securities Act, provides a safe harbor from the registration, meaning you don't qualify if you're exempt, from the registration requirement of the Securities Act of 1933, which is applicable to you. 144 applies to those people coming to you to use it. 144A applies to you. But the reason why I nonetheless read 144 is so you can know that this is the bounds as to which and how they can use your equitable interest, which is 1% of whatever you've established as the worth attached to that birth certificate, and revolving period of 90 days. I hope you see what's going on here. These are premise you must know, because these are the language that will be in your PPM. Rule 144A provides safe harbor from the registration requirements of Securities Act of 1933 for certain private resale. It's called resale because that PPM is actually the private offering. The moment they put an IPO, they are reselling it. You've already closed with them, they're reselling it. The closure is that, okay, once we resell it in the public market, we'll now give you a certain percentage of this value that you're selling to us privately. Certain private resale of minimum $500,000 unit of restricted securities to qualify institutional buyers, which generally are large institutional investors that own at least 100 million in investable asset. When a broker or dealer is selling, here goes that word, broker. When a broker or dealer is selling securities in reliance on Rule 144A, it may make offers to non-qualified institutional buyers through general solicitations following an amendment to Rule in 2012. These people keep doing things that just opens the door for you over and over and over. These are the reasons why I say the system is perfect. Most of these things people don't look into. Since its adoption, Rule 144A has greatly increased the liquidity of the securities affected, meaning your ability to cash out on that birth certificate. This is because the institution can now trade these formerly restricted securities amongst themselves, thereby eliminating the restrictions that are imposed to protect the public. In other words, you can do things privately and make money from it. It's a summary of it. Rule 144A, as implemented to include foreign companies to sell securities in the U.S. capital market for firm registered with SEC or a foreign company providing information to SEC financial statements, needs not be provided to buyers. Rule 144A has become the principal, quote, safe harbor on which non-U.S. companies rely when accessing U.S. capital markets. A video was done in the past explaining safe harbor. Now you see also the reason why you do certain things when it comes to foreign trustees. There you have it. They give you the reference straight from the horse's mouth, SEC.gov, and the Securities and Exchange Commission themselves. At least you can't say someone's not showing you these things a step at a time. Me knowing these things does me no good if I'm just telling you do this, do that, do this, do that, unless you know it. Most people go to school for 10 years and do continuous education through their professional career, and they don't learn jack shit about these things. But they go to work every day wearing a suit and tie, dumb as a rock. If you noticed earlier, as we read the Securities Act of 1933, it mentioned something about Section 3A. This Section 3A is one of the portions where the exemption comes in. Securities Act of 1933, exempted securities. Section 3, 77CA. Except as hereinafter expressly provided, the provisions of this title shall not apply to any of the following classes of security. They reserve the first one to add later in the future in case other things come up. 2. Any securities issued or guaranteed by the United States or territory thereof, or by District of Columbia, or by any state of the United States, or by any political subdivision of a state or territory, aka county. Whenever the county issued that birth certificate, they guaranteed its existence. Oh my goodness. If only you have any idea what we're reading actually, it's direct as possible. They're telling you the birth certificate is, if you're doing anything related to the birth certificate privately, it's exempt from registration is what they're telling you. Or by any public instrumentality of one or more state or territories, or by any person controlled or supervised by and acting as an instrumentality of the government of the United States pursuant to authority granted by the Congress of the United States, or any certificate of deposit, for any of the foregoing, or any securities issued or guaranteed by a bank, or any, when people speak of private banking, right? Or any securities issued by or representing an interest in or a direct obligation of Federal Reserve Bank. This is not you. You're not representing any interest of Federal Reserve Bank. Or, remember, it keeps using this qualifying term, or. Meaning there are many things this applies to. This is quite a lot of exemptions, isn't it? For something so important and intricate to how they run their stuff. Think about why they have all this going on here. They're covering their ass because they're confident that you would not find out about it. Or any interest or participation in any common trust fund or similar fund that is excluded from definition of the term investment company. Let's read that again. Or any interest or participation in any common trust fund. I wonder who's using a trust in this situation to fund these transactions. I wonder. Or similar fund. You know what? Don't even use trust. But of course, we know trust has a lot of perks and a lot of protection, so it would be smart to do so. Or similar fund that is excluded from the definition of the term investment company. You're not an investment company. The people coming to you are. Under Section 3C3 of the Investment Company Act of 1940. I mentioned this towards the beginning, this Law Investment Company Act of 1940. This Investment Company Act is what defines the different types of investors. The creditor investor, the qualified investor, the sophisticated investor, the insider investor, and the ultimate investor. Or any securities which is an industrial development bond, blah, 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 blah. That's not what it is, long-winded stuff. But the part we're looking for is the beginning portion of who created it and how it's going to be used. I'm showing you from the horse's mouth in previous videos, and I'm showing you the direct language of the law that you must know. Me knowing this and just telling you it exists is not enough. You have to know this. And those are the percentage and increments you will have as your terms and conditions within your PPM. And that's really what PPM means. We've shown all that. We've shown the origin of it. We've shown how they function, what their limitation is, what you do, what you don't do, what you can do, what you cannot do, and ways out of certain things, a problem or solution. I think this video is long enough for now. My back is kind of hurting. We'll put an end to this. It's probably going to be split into parts. But until next time, we'll go over other details, such as the Investment Company Act and other things. Until next time, take care. Best of luck.